Good morning, everybody, to today's third breakfast meeting on the South China Sea. I'm happy to see an offline audience that bears with us, and there's also an online audience. And I'm also very happy to welcome our today's guests, Knut Einar Skodvin, who is a professor in law at the Faculty of Law at the University of Bergen. His research focuses on the law of armed warfare and international law of the sea. And I learned today that he wrote his dissertation on freedom of navigation in the exclusive economic zone under the LOS Convention. So something very relevant to today's talk, although he didn't focus on China, he told me, but still in terms of expertise, very relevant for our today's talk. Then I welcome Thomas Eder, who unfortunately can only join us online. Like Alfred in our first meeting, he was supposed to be with us, sitting on the stage with us, but unfortunately his flight was also cancelled. So Thomas joins us online from Vienna. He's a researcher at the Austrian Institute for International Affairs. Thomas also worked for Marinaccio, which is a very internationally renowned research and consulting institute in Berlin, very influential, which does very influential research at the European level. And he too, his research focuses on international laws and institutions. But in addition, very much focused, his research is very much focused on China, China's international relations, especially China-Europe relations, and China's international law. So today's talk is about a landmark ruling from the year 2016, when the International Court of Justice ruled against China's claim to the historic rights within its 9-dash line. And without me not being an expert on the topic, talking about the ruling, I would like to ask Thomas to tell us a little bit what the ruling is about and its significance.
All right. Well, first, thank you very much for inviting me. I'm very sorry for not being able to be in Bergen right now. I would have liked that a lot, but I'm glad I can join you this way and honored to participate. Just to nitpick with the introduction, I'm sorry, it wasn't the ICJ. It was the International Court of Justice. It was an arbitral tribunal under Annex 7 of the UN Convention on the Law of the Sea. That decided this case, but I'm going to get to that. All right. Well, then let me tell you three things. Let me tell you about the general nature of the conflict, so we know what we are talking about. A bit of history, how it got to this point, and what the Philippines actually wanted to achieve with the verdict. First, the Philippines and China long had opposing claims in the South China Sea. To two things. First, territorial sovereignty over land territory in the form of rocks or islands in the so-called Spratly Islands that we heard so much about last few days, and the Scarborough Shoal. Secondly, to law of the sea rights, and these extend from those rocks or islands or from the Philippines' main archipelago. So this is mainly these law of the sea rights. This is mainly about fisheries and oil and gas resources. Now we will leave the sovereignty disputes aside because they were not part of the arbitration. When it comes to law of the sea rights, China partly built its claim on historic rights it supposedly has within the so-called 9-dash line, which it drew on a map to encompass almost the entire South China Sea. So if we could see my first slide here, then the audience could see how China drew these 9 dashes. You see this extends down from China all the way to Malaysia and Brunei, really close to the coast and also close to the Philippine coast. Such rights are supposed to exist in parallel to the UN Convention on the Law of the Sea. Now, the short name of the convention is UNCLOS. The Philippines only relied on UNCLOS claims, most importantly to a so-called exclusive economic zone, that is 200 nautical miles, and a continental shelf extending from its main archipelago. Maybe we could see my second slide here, and then we see the overlapping claims. Now you see the light, bright red 9-dash line claim of China and the dark red, brownish claim extending from the Philippines. Now, all these rocks or islands I mentioned had been uninhabited until the disputes broke out after the Second World War. There was only some temporary usage by fishermen, and later on, soldiers were stationed there by the Republic of China, that's Taiwan, the People's Republic of China, Vietnam, Malaysia, and the Philippines. All sides fishermen used to fish in the area. And exploration for oil and gas resources is a more recent phenomenon that really heightened tensions. There was a first important standoff between the Philippines and China in 1995 when China started to build structures on Mischief Reef, which is disputed, but well within the Philippine exclusive economic zone. Later relations calmed again. There was an agreement between ASEAN, the Association of Southeast Asian Nations, which Philippines is a part of, and China, on a declaration on the conduct of parties, which was supposed to stave off disputes. But then Philippine President Aquino, who was in office 2010 to 2016, felt that China kept encroaching on Philippine rights with its unilateral fishing bans in the summer, with its interference with Philippine survey vessels for oil and gas, and with its construction activities on various rocks or islands. Now, the last straw for the Philippines was the standoff at Scarborough Shoal in 2012. Chinese fishermen had been caught catching endangered species, but the Chinese side intervened to protect them. It took control and blocked access to the entire lagoon where both sides had been traditionally fishing, and then the Philippines decided to go to court. While the arbitration then was ongoing, China built several large artificial islands in the disputed areas, and which are fit for military use, both for its Navy and Air Force. And if we could see the third slide here that I sent you, here we see Mischief Reef, which was a low tide elevation, was not above water at high tide. And then the PRC built a large artificial island with an airstrip that fighter jets can use and also fit for use for its Navy. Now, at the tribunal, finally, just constituted under UNCLOS, the Philippines wanted to achieve three things. It wanted the tribunal to affirm that a state's rights and obligations are governed by UNCLOS, and that China's 9-dash line historic claims are inconsistent with UNCLOS. Secondly, it wanted the tribunal to evaluate whether certain land features in the South China Sea are islands, rocks, or low tide elevations, and whether they are therefore open to sovereignty claims or not, and whether they have claims to large maritime zones or not. Thirdly, the Philippines wanted the tribunal to affirm that Philippine sovereign rights had been violated, and to enable it to henceforth enjoy its UNCLOS rights. In the end, the Philippine legal team convinced the tribunal on almost all counts, and China decided to boycott the proceedings, and it also swore to not comply with any findings.
Okay. Okay, thank you for this wonderful introduction. I think now everybody has a clear idea about what the ruling is about. Now my question goes to Knut. ruling in international law, I find it very intriguing because it is about states. And state is something very abstract. It's a huge organization. And the question is always who is accountable then within the state, especially with changing governments. So could you tell us a little bit about the rule and also the effects of international laws or this international dispute settlement, especially regarding compliance? How do you convince or force the state into compliance?
Well, as a general rule, you don't. And this is one of the, so when we all think about how laws are supposed to work, we tend to think about it from the national perspective, where a characteristic of national laws is that if you and I were to have a dispute, we could always take it to court. And then if I had illegally resided on your property or something, in the end, you could call the police and they would come and throw me out. Now, it could be difficult to make that happen in certain legal systems, but in the end, you would get there. International law is characterized by states coming together to create a legal system to regulate the behavior between themselves, but at the same time not wanting to give too much power to that system. So we typically speak of international law lacking what we refer to as vertical structures. There is no supreme legislator. There is a small exception for the Security Council when they're acting in the interest of international peace and security. But apart from that, we don't really have a legislator that can force you to comply with something. And there is no police force. Again, a small exception for the Security Council. They have some options, but they would again be dependent on other states coming to their aid to sort of help bring that compliance about. So international law is a legal system that sort of lacks the possibility for large-scale enforcement against their members. They are reliant on its own force, that states see that it's in their interest, that there is a legal system there, and that states thereby sort of through combined pressure will ensure compliance by other states. And that also means that in some cases, if the international society at large does not believe an issue to be important enough to sort of put sanctions behind it, to start using their power as states in relation to one another, then some rulings may be left unenforced if one of the parties to the ruling opposes it to a sufficient degree. And it also means that, but it has a more underlying mechanism that also makes it much more effective. International law has become the language of international relations between states in many regards. Now, one of the issues is then that if you violate international law in one regard, and then you come to another state and say that, you know, you guys aren't complying with something, they're going to say, yeah, well, what are you on about? So there is this, if you want to use that language, you have to comply with it. And that's the dichotomy that state faces and which really pushes them to most often comply.
So it's a little bit like social pressure.
Yes.
Yeah, okay, interesting. So China did not recognize the ruling. What were the effects of China not recognizing the ruling?
Thomas, do you want to?
Sure. Well, basically, China got really lucky, and the Philippines didn't push for implementation at all, because right before the ruling, there was a presidential election in the Philippines, and they got a new president, President Duterte, and he made a complete turnaround politically, and he said, well, actually, I want to have a rapprochement with China. I now want to actually, in his words, say goodbye to Washington, and that's what he said on his first trip abroad to Beijing. And he said the awards are useless, and I'm not going to push for implementation. But if I may, I could expand a bit. Because we heard now about the difficulties of enforcement, but also social pressures to comply, and I could say something more about shelf life, so to speak, of the awards, which may be longer than some people dealing in realpolitik might have thought in 2016. Now, I already told you about Duterte's turnaround, but actually it got a bit more complicated over the years, and there were three phases since the ruling in 2016. The initial years of Duterte, but then the final stretch in office, which was different. And then now we have the initial phase of his successor's government, President Marcos Jr. Now, fresh to office, Duterte was really interested in infrastructure investments and loans by China in the context of the so-called Belt and Road Initiative. And thought this could really chime with his own plans for development and bolster his popularity. And when it came to the South China Sea, he was really looking for joint development of oil and gas resources. Interestingly, because there were negotiations, interestingly though, these only concerned disputed areas that the arbitral tribunal had very clearly, exclusively declared to be under Philippine sovereign rights. So there was nothing beyond that that the Philippines might have claimed, which China would have been open to negotiate on. And another important note on joint development is that this has already been tried or negotiated on between China and the Philippines since the 1980s. So it's a really difficult thing to realize. But nonetheless, Duterte wanted to go down that road. And he also said that he wants a separation from his treaty ally, from the US. He ended joint maritime patrols in the South China Sea, suspended joint military exercises, and ordered US troops to leave. But several reasons then led him to tilt back to a middle course over the years. One was that the actual investments and loans from China were quite disappointing. There were not that many projects that actually got on the ground. And the second is that China kept up the pressure in the South China Sea. Joint development again did not materialize. And China kept pushing with its maritime militia, which we heard about yesterday. So these are, again, basically fishermen, organized, trained, and armed by the government, and coordinated by the government. And they, in 2019 and 20, encircled a Philippine-held island, T2 Island, to block the Philippines from infrastructure upgrades, which China was doing on its own islands. And in 2021, again, hundreds of maritime militia boats, they surrounded the disputed Whitsun Reef, well within the Philippine exclusive economic zone. And China sternly warned the Philippine Coast Guard and Navy to back off and not approach the area. So Duterte changed his mind. He did not kick out the US. He extended the so-called Visiting Forces Agreement, resumed joint military exercises, and he even fully endorsed the so-called AUKUS Security Pact between Australia, the UK, and the US, which you might have heard about. And in 2020, getting back to the arbitration, after 4 years, the Philippines finally did call on China to implement the arbitral awards. Duterte even said they are something that cannot be compromised on, and he deplored China's interference with Philippine rights, including with resupply missions to Philippine soldiers in the Spratly Islands on Second Thomas Shoal. Now, this is actually a matter the arbitral tribunal did not have jurisdiction on because of China's reservation to arbitration on military activities. So you see this shift already under Duterte, and then we have the new president this year coming in, Marcos Jr., son of the former dictator of the Philippines. Now, he initially presented himself as a continuity candidate from Duterte. He also, in the relations with China, he dismissed the awards as useless and confrontation with China as unrealistic. But much quicker than Duterte, he had a turnaround himself, and he shifted probably also on the back of public opinion polling, which overwhelmingly wants him to take a more robust stance on the South China Sea, and he's probably someone more attuned to opinion polls than Duterte. And suddenly now he called the awards indisputable and Philippine sovereign rights sacred. And he actually said that he was ready to send more Coast Guard patrols to protect fishermen. So coming back to my initial point, the awards actually may have a longer shelf life than some might have thought.
Thank you. Knut, you wanted to reply or add something?
No, I just wanted to. I think Thomas's statement here makes it shows very well how international law is also part of politics for states when you see it from a state perspective, and how they work within law and how different priorities will affect what they want to enforce at what time. And international lawyers are, just to add to the part about shelf life, international lawyers never forget anything. If you've ever said anything in any context, international lawyers will remember that. The legal basis for China's claim to the 9-dash line have been sort of difficult to ascertain. There was an article in 2013 who might have given us the first sort of proper understanding about what they really meant the legal basis was. Then there came, after the ruling in 2018, there was a 500-page article in a Chinese journal, which sort of set out a very different legal basis. The problem of the legal basis in the 2018 article, which is probably now, and Thomas can correct me on this, but probably more now where China really stands as its legal basis. The problem of it is that it may be at variance with positions that China held during the negotiations for the law of the sea convention. So there is really this, if anything is said by a state in an international law context, it is never forgotten. And this ruling is going to be part of the debate about South China Sea forever. It never goes away for China. So it's always going to be a significant problem for them in making claims in the South China Sea.
That's very interesting. You gave me the keyword law and politics. So I'm wondering, is there a relation between compliance to international law and political regime? Like if we talk about, for example, conventions, a lot of states sign conventions, climate change or whatever, or there are goals, the European Union, like they set goals for every state in order to, and states have to comply. And if they don't comply, they have to, they are fined, they have to, there are sanctions and so on. But nevertheless, like my home country, Austria, like in terms of compliance to climate change goals, not really a role model. So how, but still it's a democracy, and from a democracy you would expect that it complies with conventions. What is the relationship between international law and political regimes? Is there a pattern that we see?
So I think we need to sort of when we talk about non-compliance, I think we need to establish that we're then talking about fringe cases. International law is generally applied to by states, and states are very happy to comply because it makes their life a lot easier, because they can then rely on other states complying whenever an issue comes up for them. Where I think we can really speak of a difference from my perspective would be that for smaller states, the interest in international law being complied with is significant because we rely so much on it. From a Norwegian standpoint, we are in a fantastic building. It is decorated. It hasn't needed to be renovated because it's so new, but everything is very good. Academia in Norway is probably the best place to be an academic in the world when you think about our conditions for being so. And it's paid for by oil. Now, that's international law that says that those oil fields are Norwegian. International law says that we could tax the oil companies till kingdom come. And that's not a problem because international law says, you're fine to do that. So we are very reliant on international law and therefore we will comply. When you are a superpower or a superpower wannabe, it gets more difficult because you have policy goals that are much more at a variance with that. And sometimes you will sort of step out because the strategic value of what you want to get is so significant. So more than regime, I think there is a large-small divide. That is not to say that small states do not also from time to time figure it's worth it, but the cost side is higher.
Yeah, interesting. So regime size matters more than regime type, actually.
Because if you're, well, I haven't done the research, but that would be my impression. If you're China, you can compensate with road and belt, as Thomas pointed out. If you do something, you can try to find other ways. It's much more difficult if you're a smaller state to do that.
I completely agree. Maybe if I could add something here. I also think it's a question of size. Great powers sometimes think that strategic interests are to be valued more highly than compliance. We definitely see in the law of the sea that autocratic large powers have lately tended to ignore arbitrations or legal proceedings, not only China with the South China Sea, but also Russia now repeatedly with a case about, the first was about a Greenpeace vessel they had arrested that was called Arctic Sunrise, that was against the Netherlands. And it was ordered, Russia was ordered to release the vessel and the crew by the International Tribunal of the Law of the Sea, and it did not, it boycotted the proceedings and it did not comply. Later released them, but said it had nothing to do with the proceedings. Maybe that's not entirely true. Again, a point about shelf life, but still, it did not attend the proceedings. And then again, now with proceedings initiated by Ukraine, again, Russia boycotted the proceedings and did not comply. But we should also mention that at least these countries have ratified the United Nations Convention on the Law of the Sea. The United States has not done so. So it could not even get into a situation where it would be ordered to comply with such findings. And if you want later on, I can also say a bit about the thinking among Chinese international lawyers, and they again draw parallels to US behavior in earlier decades and try to use that to justify Chinese behavior with regard to this arbitration.
Yes, thank you. I was about to ask you about the reception of the ruling in China, especially among Chinese legal intellectuals, scholars, and scholars. So maybe you could elaborate a little bit on that?
Yes, of course. I did a lot of research into debates in the core law journals in China, in the PRC, and looked at how they evaluate this arbitration and how they criticize it, which is what they mainly do, and how they then recommend that their government respond. Now, And if you want, I could later also say something about actually these international law scholars and their relationship with the government and whether they do have influence and what their position is. But let's get briefly to how they responded to the South China Sea arbitration. Now, Chinese international lawyers very harshly criticized the arbitral tribunal. Interestingly, not the entire UNCLOS system and its part on dispute settlement. They think that the tribunal violated the system. They do not push for a new system. They actually say that China is the one protecting the system and that China is upholding international law. So here again, we also see a connection between international law and politics. This is also connected to the image that China wants to project as a responsible power upholding international law. But getting to the concrete criticisms, and maybe we can then also talk a bit more about the substance of the case if Knut also wants to add something here. The first line of criticism was that the tribunal was biased from the start because of its composition. Now, this has a lot to do, of course, with China boycotting the proceedings, because usually when there's an arbitral tribunal and there's two parties to the dispute, each party nominates an arbitrator and the two arbitrators agree on a third arbitrator, just to very crudely summarize just typical proceedings. But China didn't participate. Now, in such a case, the Convention on the Law of the Sea regulates that the president of the International Tribunal on the Law of the Sea would then come in and nominate arbitrators. Well, at this point in time, this president of the tribunal was a Japanese citizen. Now, this is already enough for Chinese scholars to say, well, then this has to be biased. And then it turned out that the persons selected by the president were mostly Europeans. And this is again enough for the Chinese side to then say, well, Europeans cannot fully understand Asian international relations and international agreements, and there was a bias against China. Now, this is the first line of criticism, and then they also think that the tribunal didn't uphold China's rights as a non-participating party. It should have scrutinized what the Philippines said more, and so forth. But actually, the tribunal did a lot to do exactly that. The main focus of Chinese international lawyers' criticism is that the arbitral tribunal on the South China Sea lacked jurisdiction. It couldn't actually speak on this matter. Now, there are several arguments here. First, they said there was no actionable dispute at all on island status. Because, and Knut alluded to that, what China said about its claims was always vague. It didn't really clarify. And it thought that this was a sort of shield to legal proceedings. And Chinese scholars also say that China never took a position on whether the individual features in the South China Sea are fully entitled islands or not. And so there could not have been a dispute about that, and that's why the Philippines wouldn't have had standing. China only claimed large maritime zones around groups of islands around supposed archipelagos, including the Spratly Islands. Secondly, the Chinese international lawyers say that the law would have required exchanges between the parties on the matter at hand, before a dispute, before legal proceedings could happen, and these exchanges didn't take place. Now, the third argument is that China submitted a reservation with regard to what could possibly be arbitrated on under UNCLOS. And this reservation said that no arbitration could ever happen on maritime delimitation, historic rights, law enforcement activities. And it said all of this was actually implicated in the arbitration at hand, and that's why there couldn't have been jurisdiction. And fourthly, another important argument, and that goes to Europeans not understanding Asia. They said that actually the parties had a binding agreement to only use negotiations to solve the disputes, among other documents via the Declaration on the Conduct of Parties that I mentioned, with ASEAN, with the Southeast Asian nations. But the tribunal found that this was just a political declaration that is not binding, which also makes sense because now China and the Southeast Asian nations are negotiating for a binding code of conduct. This had not been in place before the proceedings. All of this together about jurisdiction makes Chinese international lawyers actually accuse the tribunal members of violating general principles of international law. And they even go so far as to allude to criminal liability in certain jurisdictions for perverting the law in arbitration, as is the case in China's criminal code. So there's also vaguely threatening language in there in Chinese international lawyers' articles on the tribunal members. Very briefly on the merits, on the actual substantive claims, and Knut alluded to different definitions by the Chinese side on their 9-line claim. What do they actually claim? Now, Chinese international lawyers say, well, what is claimed is non-exclusive historic rights, and that includes such rights within the vast exclusive economic zones of the different states around the South China Sea, and the vast continental shelf. So that's seabed and subsoil resources. And in the exclusive economic zone, these historic rights also include industrial fishing, not only artisanal fishing, small scale fishing by local fishermen, but really industrial scale fishing. This is also included in China's historic rights. And they recognize that this might be a problem within the UN Convention on the Law of the Sea. So they say that this is a customary international law that exists outside UNCLOS, in parallel to UNCLOS, and that would have to be recognized. On the question of whether these specks of land in the South China Sea are fully entitled islands with vast maritime zones around them, they claim that such actually do exist, and they claim that actually the scholarly mainstream is on China's side on this, and state practice is actually on China's side. And you got to admit they do point to other offenders like Japan with Okinotorishima, which is a small speck of land in the Western Pacific, and others like the US and France. So they do have a point there, which is not to say that the tribunal made an error in legal judgment, but it's still points to it really being difficult for this point of case law to influence state and change state practice in the future. And I said that when we come to recommendations, what the government should do, the Chinese international lawyers point to the United States as justifying Chinese non-compliance, because they say all of these flaws, supposed flaws of the arbitral awards, actually make them invalid. And they say that the United States also considered wrongful exercise of jurisdiction sufficient to make judgments invalid in the so-called Nicaragua case in the 1980s, where the United States boycotted part of the proceedings at the International Court of Justice and also did not comply. So this is what they say. They say, Chinese international lawyers, stay within UNCLOS. The benefits outweigh the drawbacks. Be within the system. Influence the system from within. Do not implement the awards. Build diplomatic support. Try to influence state practice and potentially case law, and maybe even legislative developments. So the idea is that there have been implementation agreements to further clarify certain points under UNCLOS in the past, and maybe there could be new implementation agreements that could sort of overrule the arbitral awards in China's favor. So this is a more mid to long term plan of something that the Chinese legal community wants to build to.
Thank you for this very detailed elaboration. So like from what I get from this picture is that intellectuals or legal scholars in China very much back the state and its narrative. And this appears to me quite different from other policy fields where we see the intellectuals' position, a greater variety of positions across intellectuals, whether they're establishment intellectuals or others. Please correct me if I'm wrong, but I would like to go back to one of the earlier arguments that you explained, that China or Chinese legal scholars criticized the selection of the arbitrators. So Knut, how much legitimacy does China's argument of its selection, like that it's mainly composed of Europeans that don't understand Asia or China in particular, have? Because, for example, the UN has very long been criticized for representing the interests of industrialized developed state and instead of a greater inclusion of and representation of less developed and smaller states. So what do you think about this argument?
Well, that's a tough question. So international law has a checkered history. International law because international law has also been a tool for states. It has been used for nefarious purposes. And I think the answer to the question depends very much from where you were coming from. So under the negotiations for the Law of the Sea Convention, China positioned itself along with developing states. And it positioned itself very strongly in a position of how it wanted to develop the law and take the side with the developing states and hinder the activities of developed states in robbing developing states of their natural resources. So they took a very strong stance in that position and sort of wanted to be a champion of that voice. And I think you can this sort of comes back to that. And then if you see international law as having been used as a tool for oppression and other nefarious purposes, then a all-European panel that decides on something that happens in Asia, that has traction, that has automatic sort of, there is something to that. Whereas if you more of accept that the law is what it is and it has its drawbacks, but you come from it from a more how should this be applied to this conflict, then the case of nationality and where people come from didn't matter so much. And I think those two positions will very much dictate the answer to that. So I think which shoes you take on and which capital you place those shoes in might very well have a lot to say on how you will answer that question. But Thomas, I mean, you've looked more into this in particular for South China Sea than I have. So,
I mean, I completely agree. There was, I mean, not only the composition of the tribunal, but the Philippines legal team arguing without an opponent, a lawyer's dream, of course, gives the proceedings a whiff of unfairness. And it cannot escape that. But I mean, as I alluded to, the tribunal did go through great lengths to provide China with transcripts every day, invited to join the proceedings at any point, send it all documents, go through all its arguments that it ventured in diplomatic statements and documents, and even go through other potential arguments that it could make, but hadn't yet in diplomatic positions. So I do think the tribunal did make a real effort there. And then the composition again, it goes back to China not participating. If it would have been willing to go to court with the Philippines, then the two sides under UNCLOS would have had the option of choosing how they want to settle this matter. They could have gone to the International Court of Justice. They could have gone to the International Tribunal on the Law of the Sea, and they could have chosen arbitration. Now, the International Court of Justice, probably rightfully so, had a rather bad reputation in the 1960s and 70s and before that. But then it got much better, and it actually had and has now a representation of all geographical regions and legal systems and legal traditions. And the International Tribunal on the Law of the Sea also has, by the laws establishing it, such a representation of all regions and legal traditions. So these could have been reasons for China to say, well, let's go to one of these institutions, but it didn't participate. And the fallback option in such a case under UNCLOS is arbitration. And under arbitration, there is no legal ground that would require all regions and legal traditions to be represented. So the president of the International Tribunal of the Law of the Sea selecting these arbitrators had a free hand. And he selected reputable international lawyers that had judged a lot of important cases, and one can hardly fault him for that. Maybe it would have made sense to be sensitive to this issue, but it doesn't invalidate the findings.
Of course, that's one of the major problems, that if states are allowed to come in the aftermath and say that, we didn't like the tribunal when they're up with them, we didn't like their decision on jurisdiction, and we didn't like what they'd done, and you therefore should be able to escape the jurisdiction, then the entire system falls together. Because then what you will always do is that you will make a token objection to jurisdiction before the tribunal starts, and then you will afterwards say, but even if you participated, but we made that objection and they were wrong in deciding it the way they did, so the ruling doesn't apply. So it's sort of, it's a way of arguing that sort of, it undermines the system of dispute resolution in totality.
Okay, interesting. Time is running, and we have about 10 minutes left. And so I would also like to give the audience a chance to raise questions, both in the online and in the offline. So please go for it. We have one question in the online audience. I will read it out to everybody. Many thanks for the very interesting perspective of the South China Sea legal scenario and the intricacies involved in arbitration and their limitations. Are there similar cases like South China arbitration involving China and other countries? There are possibly similar cases arising in the Arctic region and areas involved in the Belt and Road strategy of China. Is there a general trend or pattern? I don't know whom of you would like to start with answering, or?
I mean, I could very briefly just say on China, well, no, China does not accept jurisdiction on law of the sea matters that might involve what it has listed as maritime delimitation, historic rights, and so forth. Actually, it hasn't been part of hasn't participated in law of the sea proceedings at all. I mean, disputes, contentious proceedings. What it did do, and maybe this is a sort of hopeful trend for participation, it did participate in advisory proceedings under UNCLOS. So it did sort of begin to familiarize itself with the International Tribunal on Law of the Sea on the advisory side, and it also did make comments and make its own submission to the Commission on the Limits of the Continental Shelf. So this also goes to potential limits of maritime claims, but is something entirely different from contentious proceedings.
Knut?
I think it's an interesting feature what Thomas spoke of earlier, that China, in regard of the South China Sea, they try to take it out of the Law of the Sea Convention narrative. It's something on the side of the Law of the Sea Convention, which means that they can apply the Law of the Sea Convention in every other relation. So they are trying to move this question out of the context of the Law of the Sea Convention, and thereby they can sort of stay with the trend of the Law of the Sea Convention. So there is a willingness from China's side to stay within the Law of the Sea Convention and its ambit, just not in this case, which we will remove from the ambit of in the entire convention. And I think in general, that is the trend we see from state. There is support from the Law of the Sea Convention, and disputes are settled by negotiations. There are very, very few disputes that reach conflict resolution mechanisms. So states, the clear tendency in how states deal with these kind of issues is still negotiations. Mm-hmm. And I think we would expect that trend to continue in other regards.
I mean, maybe there is a trend, though, in the Indian Ocean, for example, of neighboring countries going to legal proceedings, dispute settlement, to settle their maritime borders. So, for example, Myanmar and Bangladesh and India, and I think there was just something on Kenya and Somalia. So in the wider Indian Ocean region, there is a trend where states also say, well, actually, maybe it's not a bad thing to have a third party come in and solve our dispute, sort of as a neutral arbiter, and then it can also perhaps depoliticize the dispute. And we can also go to our own population and say, well, we tried, and this is the outcome, and now we have to comply with it.
Okay, thank you. Do we have another question, maybe here in the audience? No, and there doesn't seem to be a question online. So to wrap up, I would like to ask Knut and Thomas to give very brief, in 2 or 3 sentences, an outlook. So how is this dispute, according to you, going to develop in the future? And the role of international law in this area, will it have like a positive effect in the long run, or like will it help in the long run to help in dispute settlement in this area or not?
From my perspective, I think China, as Thomas said, is playing the long game, and it's going to remain a contentious issue for some time, and China is going to keep push for it to reach a conclusion through negotiations. And then I think how it is going to come out is going to depend a lot on other geopolitical incidents that happen, because this is part of a larger framework of geopolitical interests that are meeting, and this has to find its place within that pattern.
Okay, thank you. Thomas?
Yes, I think it could actually be a positive factor. The arbitration awards, the legal proceedings, making it easier in the future to reach negotiated solutions, because the tribunal did decide that there is no fully entitled island in the southern South China Sea and in the Spratly Islands. Now, if all of these specks of land only have a maximum 12 nautical mile territorial sea claim, then there's less overlapping potential claims. Maybe there's an easier time then for the different states around the South China Sea to find eventual agreements. But this, of course, depends very much on politics and especially in China, how open they are to making compromises, and I don't see that yet under President Xi Jinping, who has very much driven a hard line here, and I think this issue with him also being the president that built all these artificial islands to create facts on the ground, this is very much connected to him, and I think he can not really easily step back. So we would probably have to look at least at the 2030s for some further progress in settling these disputes.
I think according to Xi Jinping, after 2035, yes. So maybe yes, exactly. Even later. Okay, thank you very much to my 2 guests who made it, like the other 3 guests, a very easy task for me to moderate the discussion. And thank you also to the audience here in the at Bergen Global and in the offline for bearing with us. And with this, I conclude the 3-day session on the South China Sea. Thank you.